R on the application of ZO Somalia and others against Secretary of State for the Home Department.
Mr. Tam, it's your appeal.
May it please your Lordships. Indeed, in this matter, learned friend Mr. Beard and I appear for the Secretary of State, the appellant in this case. Learned friends Mr. Wilson and Mr. Nathan appear for the respondent ZO, and learned friends Mr. Fordham and Mr. Jacobs appear for the respondent MM. Lord, we've arranged ourselves in the court in this way under guidance. I hope that doesn't cause any inconvenience.
No.
Lords, this is an appeal from a decision of the Court of Appeal in which the Court of Appeal considered three cases. The third of those cases was that of an individual DT. They are all three of those individuals people who have had their asylum applications, initial asylum applications, definitively refused, including appeals to the independent appellate authorities. But they did not depart the United Kingdom, and their cases have been queuing with numerous others for resolution by part of the UK border agency known as the Case Resolution Directorate, which is dealing with a large number of such cases. In the course of the CRD's business, DT's case came up for consideration, and he was granted indefinite leave to remain in the United Kingdom. As the appeal had become totally academic for him, he decided to take no further part in the proceedings, and after discussions between the parties, the Secretary of State applied and was granted permission to withdraw his appeal in relation to DT, and that is why there are only two respondents before the court now. The legal issues, though, remain live in respect of both ZO and MM. And their facts very simply exemplify the situation in which the legal issues arise.
Is it the case that both appellants now have permission to work?
Yes, as a matter of fact, they have been granted permission to work since the decision of the Court of Appeal.
Yeah.
But the legal issue remains live because although it arises in the context of an application for permission to work, in reality this is the first of the issues is about the interpretation of the Reception Directive, where the respondents contend that the whole of the Reception Directive is triggered in the circumstances of these individuals' cases. And so, despite the fact that they actually have permission to work, there are other issues that might, in theory at least, arise in their cases. Indeed, the legal issue is one which is of some importance across the work of the Case Resolution Directorate, and so it remains appropriate for the court to consider that, and I think that is agreed on all sides. The situation is essentially this, that the individuals have had their asylum applications refused, they have had unsuccessful appeals, and then they have made thereafter made further submissions asserting that they should be allowed to stay in the United Kingdom on the basis of material which they say amounts to a fresh claim for asylum. That is a concept which we apply in domestic law, but that is in fact what they say that they have done.
And does that require a decision under Rule 353?
Yes, that is the decision to which Rule 353 refers, but it is a decision which is of limited importance. I don't want to underplay that, but it's a decision which is taken at the same time as a decision whether to accept or reject those further submissions, because the decision as to whether or not there is a fresh claim is only important if the individual's further submissions are in fact rejected.
Yes.
Because then it governs whether or not there is a fresh right of appeal.
Yes, exactly.
And so that there is a very good practical and legal reason why that decision is made at the same time. But that is indeed the decision referred to in Rule 353, and I know that the court has been looking at that.
Well, we had a vexed case called ZT, which Kosovo, I think, which raised that issue.
Well, yes, well, ZT Kosovo was a case that raised that issue, and then the court looked at it again in a case called BA Nigeria,
yes,
dealing with the 2002 Act, and there were various decisions in those cases about the exact applicability of the fresh claim decision and what effect that has in the current state of the statutory schemes. Fortunately, I don't think we have to go into that in the course of this case, but that is the factual situation in which the respondents now are. They are waiting for the Secretary of State's decision on those further submissions, as I say, including a decision on the question of whether a fresh claim has been made, if indeed it turns out to be relevant. Initially, both of the respondents complained about the length of time which it was taking for the Secretary of State to deal with their further submissions. But in other litigation that has been before the High Court, the Secretary of State's plan for dealing with the backlog has, to cut a long story short, been looked at and been, or not been disapproved, despite the length of time which it will take, as a matter of fact, to deal with all of the cases that are in the backlog. There was evidence before the Court of Appeal, which your Lordships have at the end of Appendix 1, with statistics and
Yeah, just which page gives the actual figures? So how many of these outstanding and how long on average they're taking?
Well,
I know it's in this affidavit.
It's a statement of Emily Miles, which starts on page 58.
I know.
Where
are the punchlines?
The key is that the plan is to complete all of the backlog by 2011. You'll see that on page 70 at the top, towards the end of paragraph 33. And then on page 72, in paragraph 42, you'll see an extract from a letter from the Permanent Secretary in January of 2009, which says that the UK Border Agency remains confident that the cases would all be cleared by summer 2011.
Yes.
Now, I should draw to the Court's attention that this witness statement was dated March 2009. We haven't got precise figures before the Court, but we have asked whether that deadline or that target remains realistic, and our instructions are that it does. So things remain on track.
And are we told how many a year there are of these further applications?
The cases that are in the backlog are cases, essentially a pool of cases that need to be dealt with. So it is not a question of applications being made and then coming into the CRD stock. The CRD is dealing with a particular identified pool of cases. And that is what is being worked through at the present time.
Is the table on page 66 any help in understanding that point?
It does to an extent, because it shows where the backlog came from in relation to the very high numbers of applications that were made in starting particularly in 1999.
I mean, this figure in paragraph 28, page 68, of 400,000 to 450,000, this directorate was set up to deal with this backlog.
That's right, it was, yes.
I mean, are they all cases following an initial refusal with a further application?
The situation is not quite as clear as that. What the Home Secretary said was that there were that many case records in the Home Office that needed to be dealt with, but not all of those were necessarily equated to asylum applicants because of quite a number of data difficulties, such as the duplication of case records. So there might be more than one case record for an individual person, and there might be case records that still existed where the individual had in fact already left the country or had for some other reason become eligible to stay. For example, they become EU citizens.
So that lot isn't all cases that fall for consideration under 353?
No, not necessarily.
Any sort of estimate at all as to how many at that date fell for consideration under 353?
I think that the closest that information that we have is something which we've set out in our printed case, which is that there's an estimate that about 20 to 25% of the cases have further submissions made on them. And so if further submissions have been made, it is likely that they would have to be looked at under paragraph 353 if they are asylum applications. One of the reasons why it isn't clear is because you can't get accurate figures without going through and looking at all the submissions, and that is one of the things which we are trying not to do.
I was just aiming for a ballpark figure. The answer is no, and you can't say how many 353s a year accrue, roughly.
No, we can see if we can provide any.
Well, I mean, just
better figures,
just to get something like the scale of it, but
yeah. Well, your Lordship has the raw figure of the number of case records that are having to be worked through over this 5-year period to find out exactly what has gone on in the individual case, to find out whether the person is here, to find out whether or not there's anything that needs to be dealt with before the case is finally resolved and put away as a fully completed case. And that shows some indication of the enormity of the task that faces the CRD. But they are working to their target, and that looks like that is going to be adhered to.
Yes.
The original complaints made by the respondents about the length of time that it was taken to deal with the claims were therefore rejected or dismissed following the consideration by the High Court. But in parallel to that, each of the respondents asked the Secretary of State for permission to work, which was refused, and by various procedural devices, those became the subject matter of their applications for judicial review, and that is how they have come before the courts and ultimately before your Lordships today. They raised two substantive legal issues. The first one is a question of interpretation of a European measure, the Reception Directive, or Reception Conditions Directive, as it's sometimes called. And the question is whether, on a proper interpretation of that directive, a person who is in the position of these respondents, that is to say they've been through the system completely a first time round, and then they are making further submissions and asking to go back into the system for a second time, whether the making of those further submissions themselves trigger the provisions of the Reception Directive again, so that they are once more entitled to all of the benefits of the Reception Directive, including, but not limited to, the provision of Article 11 that would allow them permission to work after a period of time. So that is the first legal issue. There is a procedural issue that follows on from that, which is the second issue identified in the Statement of Facts and Issues, which is whether this is a question of interpretation of a European measure, which requires a reference to the European Court of Justice in the light of the competing arguments that are being placed before your Lordships today. The other substantive legal issue is one which has had a slightly complex procedural history. It relates to an Article 8 challenge to the Secretary of State's policy of not granting permission to work to individuals in the position of the respondents. This was a challenge that was brought originally by DT alone, and which was heard and decided by Mr. Justice Blake. Mr. Justice Blake considered that the policy was overbroad and infringed Article 8 for that reason, and declared accordingly, but without granting DT any individual relief. When the matter came before the Court of Appeal, it was the Secretary of State who was appealing in DT's case, and that was linked with these respondents' appeal from His Honour Judge Mackey's decision on the reception directive. The Court of Appeal heard argument on the directive point first, and came to a conclusion which they said meant it was unnecessary for them to consider the Article 8 point. The result of that was that there is only the decision of Mr. Justice Blake on that. I say only not in any disparaging sense, but because Mr. Justice Blake noted that he really had very little evidence before him of justification. And it was primarily for that purpose that we adduced the evidence of Miss Miles, which I've just referred the court to, in the form of that witness statement, primarily intended to show the Court of Appeal on the Article 8 argument the reasons why the policy is as it is, and what the disadvantages would be if any of the solutions which DT had been suggesting were in fact adopted. And therefore to show the court that if there is any interference with Article 8 rights as a matter of law, which is in dispute, that interference is justified. The Court of Appeal never looked at that, and as you've seen, that evidence is now a year old and more. And so this second substantive legal issue about the compatibility of the policy with Article 8 is one that also raises a procedural question as to whether or not this court should deal with it now, or whether it should be remitted to the Court of Appeal to deal with, and particularly in the light of any evidence that there might be.
If you were, supposing we were against you, Mr. Tam, would we get to the Article 8 point, or would we be in the same position as the Court of Appeal?
If you considered that our argument on the directive was so bad that not even a reference was required to ascertain the true meaning of the directive, then it would be unnecessary for this court to deal with the Article 8 argument. And that was the approach taken by the Court of Appeal. So in that event alone, it would become unnecessary. We respectfully say that this court should adopt and approve the construction of the directive which we advance.
I mean, are you really saying that we should actually go so far as to say that the Court of Appeal and the other judges, it's clear that they were all wrong?
Well, that is our primary argument. But if you're against us on that, then there is certainly room for doubt about it, and sufficient room for doubt that a reference is required. And in the chronology of this particular litigation, your lordships are the first court that has actually had the power to make a reference for reasons which we've set out in our printed case. And so we say that it should be one of those two courses of action. But if your lordships do either of those, then a decision will need to be taken about whether your lordships want to descend into the evidence on justification essentially for the first time, because it was not before Mr. Justice Blake.
Yes.
So, Lords, with that introduction, may I then start with the first of the legal issues, namely the construction of the directive. Your Lordships have seen the text of many of the provisions set out in our printed cases and so on, but can I start by saying this? There is, in substance, just this issue between the parties, which is, does the reception directive apply only to those who are being received, I put that word in quotes, received, for the first time as asylum seekers
Sorry, does it apply only to those
who are being, quotes, received, unquote, for the first time as asylum seekers.
As what?
As asylum seekers. As the Secretary of State contends is its clear purpose, backed by indications in the text of the Reception Directive itself? Or should it be given a strictly literal interpretation, as the respondents contend, so that anyone who at any time and with whatever merit or lack of it says, I have a fear of going home, can claim the benefit of the directive, even if they have already been through the asylum system once, or possibly more than once. In many ways, this is quite a short point of construction. The first point that we need to make about this is its context and the chronology. Your Lordships have seen it set out, and it's common ground that the Reception Directive forms part of the construction of a common European asylum system. It was one of the earlier measures in that system. And it was adopted in January of 2003, very soon before the Dublin regulation, which will feature later in the argument. The exact dates were the 27th of January 2003 for the Reception Directive, and the 18th of February 2003 for the Dublin regulation. The Dublin regulation came into force on the 17th of March of that year, because as a regulation it has immediate effect. The directive, however, had a transposition period which ended on the 6th of February 2005, by which time the member states were required to have transposed its provisions into national law. We make that point, and the point about it being an earlier measure, because the learned friends place great reliance on the Procedures Directive, which was another measure in the Common European Asylum System, but which came later. The Procedures Directive was not adopted until the 1st of December 2005, that is to say some 10 months or so, after the Reception Directive had to be transposed into national law. Thus, we say that however, or whatever assistance one can get or not from the Procedures Directive, one has to remember that the Reception Directive, the measure that we are looking at, is one which had to have a settled meaning before the Procedures Directive had been agreed. And so it is on the Reception Directive and its text that we ask to focus.
Is the phrase settled meaning a term of art which is found in the jurisprudence?
I'm not using it in that sense, but it's simply the concept that when there was a time of some 10 months when the Reception Directive had to have been fully transposed by all the member states, with whatever meaning it has, but when the Procedures Directive had not yet been agreed by the member states. So by February of 2005, one would have thought that it should have been possible to have an answer to the question whether the Reception Directive applies only to those being received for the first time as asylum seekers.
Well, Mr. Hammond, does your argument depend on actually reception directive having a different meaning from the procedures directive?
The way we put it is this. The Procedures Directive it has made some specific provision for those applying for a second time or those making further submissions. The Reception Directive does not do that, and the Reception Directive has a scope which is therefore more limited than that of the Procedures Directive.
But, I mean, as far as Article 2 is concerned, which is the definition provision, you say you give it a different definition than one from the other?
Yeah. The way we put it is this, and the reason I describe the respondent's approach as a strictly literal interpretation is this. If you look at the definition the definitions in Article 2.
Shall we, where
Yes,
are these
What's the most
directives?
convenient place? Is it
It's
monthly?
Volume 4, Tab 47.
Thank you.
This is the reception directive.
This is the Reception Directive.
And the procedure is just for reference is 49, is it? So it's in the same bundle.
Yes, the Procedures Directive and the Reception Directive are in the same bundle 4 of the authorities.
Yeah.
The Reception Directive at 47.
Yeah.
And what learned friends do is that they place particular emphasis on the definition application for asylum and then applicant or asylum seeker, B and C of Article 2. And in essence, what they say is this: whenever somebody has said something which falls within that definition, they have triggered the Reception Directive. And that, we say, is a completely literal approach to it, which is to say, if you do something that literally falls within that definition, you then take that through to every provision in the directive and say, it now applies to me. And we say that that is to miss one of the important points about the Reception Directive, which is its scope. It simply doesn't extend that far. It covers a particular category of case. And if you're within that particular category of case and you then satisfy the terms of the directive, then you can claim the benefits of it.
Could I just be clear? We seem to have moved a little bit from what we were discussing a moment ago, which was the relevance of the Procedures Directive. Just suppose the Procedures Directive had been adopted on the same day as the Reception Directive. You would still be running your arguments, I imagine, that the purpose and scope of the two directives are the same. Would you or wouldn't you?
Well, our argument is that the scope of the directives is different.
I'm sorry, the scope and meaning is different. I'm sorry.
Different, yes.
You would be running that, and that is how you would be seeking to distinguish the definition in Article 2 of the Procedures Directive from the definition in the Reception Directive.
The argument is not so much the concentrating on the words of the definitions, but on the scope of the directives, and asking oneself the question: is it really intended to cover this category of case? And so the example that your Lordship puts to me is one which is, in some senses, perhaps dangerously hypothetical, because if the Reception Directive and the Procedures Directive had been concluded on the same day, one might have expected somebody at least to say, well, the Procedures Directive makes some special provision for people who have gone through the system once already and have made further submissions or a second application, whatever you want to call it. How are we going to deal with that in relation to in the Reception Directive? Should we say something about that? And so if they had been concluded at the same time, one might actually expect to find the Reception Directive saying something about people who've applied for the second time. And one of the points we make, I'm sorry, I've now got slightly out of order, one of the points we make about the Reception Directive is that it is absolutely silent about people who have already been through the system once and who are coming up for the second time.
Well, I think that's not accepted by your opponents.
No, well, I'll come to show your Lordships well, first of all, that it is actually on its face silent about that. But secondly, if you look at the text of some of the provisions, they simply don't make good sense for people who have been through the system once and are then seeking to re-enter the system a second time.
But is it your case that the Procedures Directive is irrelevant to the exercise we're on?
Yes, it is. That is our case. It is irrelevant.
Is that because it came later in time, or is it because the scope of it is so different from the scope of the Reception Directive?
Well, we say that there's no assistance to be gained from the Procedures Directive because as a measure that was later in time, you can't work backwards to try and change the meaning of the Reception Directive. You really ought to ask yourself the question, what did the Reception Directive mean when it stood on its own? Because it must have had a meaning then. It must have been one thing or the other at that stage. And second, if you then put them side by side, and bearing in mind that one came after the other, you can see how the Procedures Directive has had something perhaps bolted onto the side of it to deal with this extra category of case, the people who are coming round for a second time. And that explains why, if you look at the Reception Directive on its own, it naturally covers everybody who's coming through the asylum system for the first time, but you have to strain and struggle to find decent meaning for it for a second time round applicant. Whereas if you look at the Procedures Directive and you say, what of this applies to a first time applicant? The answers are there. What of the Procedures Directive applies to a subsequent applicant? The answers are also there because the Procedures Directive has looked at it and has made the special provision for that type of case.
Well, at the moment, the furthest we've got into the detail is to look at the provisions of Article 2, B and C, and am I right that they are precisely the same in the Procedures Directive as they are in the Reception Directive?
Yes, they are. And that is the way that learned friends get into it, by just looking at the words of the definitions and saying, I fall within this definition, therefore I claim the benefit of the Reception Directive.
And I don't want to jump too far ahead of you, but there is a significant word in little c, isn't there? The phrase in respect of which, as opposed to in respect of whom. And it said that, of course, if it had said in respect of whom, final decision has not yet been taken, that would narrow it down plainly to the first reception, whereas the way it's worded is perfectly capable of being used in the Procedures Directive because it's looking at the decision and not the person.
Yes, and that's an argument where that word allows the respondents to escape one of the problems with their argument, but it doesn't escape the other problem, which is that the applicant or asylum seeker in C needs to have made an application for asylum, and whether or not they have done so is pretty much the question in issue. Have they made an application for asylum within the scope of the Reception Directive?
You've said that if both provisions were enacted or had come into force on the same day, you would have expected some reference in the Procedures Directive to be made to the Reception Directive.
No, with respect, what we say is this, that if the Procedures Directive and the Reception Directive had been enacted at the same time, one would have expected the Reception Directive to say something about second applications. The issue having been raised and addressed and thought about and addressed and provision made in the Procedures Directive.
Yes, I'm sorry, I misunderstood what you said. But if one expected that, one would have expected that, why would one not expect, if your argument is correct, the Procedures Directive to make that plain, that it didn't apply to the Reception Directive, albeit that it was enacted some months later?
The Procedures Directive makes its own provision for subsequent applications. The difficulty is not in the descriptions of what an application for asylum or an applicant or an asylum seeker are, or not so much that, as the question of whether the person who is making a second application or attempting to make a second application comes within the scope of the Reception Directive at all. Is the Reception Directive actually intended to refer to that type of case at all? Or is it, the analogy that we draw from treaties, is it outside the scope, ratione materiae?
Well, if the Procedures Directive is silent in relation to the Reception Directive, can it not be said that that is so because it proceeds on the premise that the Reception Directive applies?
Well, that is an argument which learned friends will no doubt rely on. But we say that if you look at the text of the Reception Directive itself, and I'll come on to that because I do need to look at some of the detailed provisions. And if one asks oneself the question, does this make sense for a second time round asylum seeker? Does this make any sense for a person who's trying to get back into the system for the second time? The only answer that can be offered by the respondents in respect of many of these provisions is, well, possibly, but if you strain its meaning and you try and find some way of making it work. There are many provisions in the Reception Directive that are simply unnatural when you try to apply them to a second time round asylum seeker. And you have to work quite hard to make it work.
I don't find that an easy proposition to grasp until we've looked more fully at the Reception Directive.
Indeed.
But one has to assume that some at least of the second applicants will succeed. I mean, there may have been a genuine flaw in the first application, and on further consideration it's understood that actually it could be better presented.
Indeed.
And so I know your position is large numbers of these cases are undeserving, but there could be some that are deserving, and the rights that are given, one might think, were quite properly to be made available to them. And we'll come on, no doubt, to Article 16 and the various provisions there about withdrawal or reduction, which may provide some kind of safety valve against undeserving cases.
Well, that is right, but we say that the mere fact that some second time round cases may be substantively meritorious doesn't mean that all of these provisions are necessary. These are not the only provisions that govern how asylum seekers should be looked after, using asylum seekers in the broad sense of people who have come here, and even if they have failed. We have domestic provisions which, in some respects, may exceed what the directives require. We have obligations under the ECHR, and a number of cases relating to that have come before your lordships in recent years. There is no question of the person who has failed first time round not being looked after as the law requires.
Yes, but these other provisions in the law are available for first time applicants as well, aren't they?
Some of them are, some of them aren't, and there are different provisions laid down by domestic legislation for different types of case or people who are at different stages of the process, and so that there is a whole panoply of provision for this, and that doesn't answer that means that one doesn't have to say, well, just because there are some substantively meritorious cases, therefore all of these provisions must be applied to all people in that category.
Mr. Tam, one can very easily think of a meritorious case. You fail, perhaps narrowly, on your first application, the position in your home country changes radically, dramatically against you, make a fresh application, what do they call surplus or something like that, and on the face of it, it's a strong case, but nobody looks at it for 5 years. Now, if you're right, meantime, none of the protections available under the Reception Directive, take Article 15, healthcare. I mean, we no doubt have an absolutely splendid system for dealing with it, but actually there is no obligation under Article 15. Is that right on your submission?
That is right.
And so in another country which doesn't have our own system, there it is. They escape the requirements of this directive.
Well, they don't fall within the requirements of this directive, but every member state is subject to other obligations as well. For example, every member state is subject to ECHR obligations.
Well, I know, but I mean, heavens above, there must be some point in Article 15 having this requirement.
Yes.
But
Well,
you say it simply, it's just not applying in respect of a second application.
The point is that people who come here and are in the asylum system for the first time are in a special category because they have come and lodged their first time round applications. Those applications have not been looked at substantively. Without deciding that, you can't tell whether or not these people are meritorious or not, and therefore the first time round asylum seeker is entitled to essentially a measure of generosity provided by the reception directive. That is the point of all of these provisions here. If you're here and you're being received or welcomed for the first time as an asylum seeker, you get this panoply of benefits. Anybody who has been through the system completely once and who has failed has, as a matter of fact, had their application rejected. That is not something which one simply ignores merely because there is a possibility that they may, on a second time round, establish that they actually have a good claim.
And in order to deal with this, surely we have to look at the preamble and some more of the provisions in the articles, because at the moment you're fencing around on generalities, and I think we really need to look at the wording to understand how significant the points are that you're making.
Lord, yes. And so may I then turn to the next submission, having made the point about the chronology and the fact that the reception directive and the procedures directive come at different times. The second submission is to look at what one gets from, or what indicators one gets about the purpose from the purpose of the reception directive from its language. The first thing that we point to, and the Court of Appeal accepted that this was a significant point in our favour, is that it deals with reception. That can't be ignored. Reception is a word which, even in English alone, has a meaning which can be clearly understood. It is not a word which applies naturally to people who have been through the asylum system for the first time and then are saying, well, hang on a second, you were wrong the first time round, I want to have another go at this.
Well, taken literally, and I think this point is made in the Court of Appeal, taken literally, reception would be on arrival. They would be greeted on arrival at the port of entry with the benefits that are accorded by this directive. But Article 3 does use the phrase, who makes an application at the border or in the territory, and one knows that people may have been in the territory for some time before they actually make the application. So the word reception has to adapt to the fact that it's not dealing literally with the entry into this country, it's dealing with the making of the application, wherever it's made.
And that is why we say that it is to do with receiving people into the asylum system, if you like, for the first time, receiving people for the first time as asylum seekers.
Well, it doesn't actually say that.
It doesn't say that. Well, it says reception. But that is, we say, the first of these indicators that if you look at it in the context of first-time asylum seekers, the word can be used entirely naturally. If you try and apply it to people who are going round a second time, you have to strain and take unnatural meanings of the words.
And a person would be in the position of being at the stage of being, as it were, a recipient until the case is decided finally against him. Is that the way it works?
The first-time asylum seeker, once he's in the system, he then benefits from these until the case is finally determined, except where the directive provides otherwise, and that there is a specific provision that I will draw attention to, yes, where it actually persists for longer than that.
We're going to come back to Article 3, are we?
Yes, because there are some more general points to deal with first, if I may.
Yes.
Because the word reception is the English word used in the English text. And one of the points that we make is that one cannot look at that in isolation. One does have to look at the other language texts of the directives. And we have set out in our case a selection of the corresponding words used in other languages, which probably shouldn't try to pronounce. But
paragraph 33.
Paragraph 33. The languages that we've selected are Dutch, French, German, Italian, and Spanish. And the translations of those words, I don't think is in dispute by learned friends. Acceptance, reception, or welcome. It's enough to give the court a flavour of what the other language versions of the directive do in its title.
But it's reception into the asylum-seeking sphere, so to speak, is that it?
Yes, being received for the first time as an asylum seeker, entering the system for the first time.
Well, you say for the first time. There's nothing in the directive which refers to the first time, is it?
I accept that, and that is why the literal interpretation is being heavily relied on by learned friends.
Well, I think it's perhaps the absence of the word first rather than the literal interpretation, but leave that aside for the moment. I mean, if the concept that you wishes to espouse is that it's reception into what I've crudely described as the asylum-seeking sphere, why should someone who is applying for the second time not also be received into that sphere?
To headline the submissions that I'm going to make, first, because there are provisions in the directive that really don't make sense for somebody coming in for the second time. And two, because if you construe the directive in that way and you extend its scope, you open the door to wide abuse.
But he can say, pointing to little c in the definition, that the law allows me to make another application because I'm still in the country. There's a system for looking at it. I'm somebody in respect to whom a final decision has not yet been taken. Admittedly, the first application was refused, but I've got this other one which is in the process. Why doesn't the definition apply to him?
Because it doesn't answer the question of whether the individual is actually within the scope of the reception directive at all.
I mean, is it a fair summary of your case that that read literally, you accept that the argument is against you, but you say that there are sufficiently powerful counter indicators in some of the other provisions which you rely upon to show that was not intended.
Indeed, and it cannot.
And that the number one, and number two is that the risk of abuse, if their argument is right, is so great that those who drafted this could not have intended that possibility. So if but for those two factors, would you be accepting that the argument against you must prevail?
We wouldn't accept that because, as we know, European measures can't be construed simply as our domestic statutes would be construed. And the answer that may be given by the European Court of Justice could be different even if I couldn't rely on those arguments. But my argument would certainly be weaker if I could not point to both textual difficulties and to the possibility of unchecked abuse.
Well, is it helpful then to look a little more at the text? Is there anything in the preamble that you'd like to draw our attention to?
There's nothing.
We ought to notice recital 12, obviously.
Yes, recital 12, which I know your Lordship's attention has been drawn to, and we of course entirely accept there are some anti-abuse provisions in the directive, but they are anti-abuse provisions, which again make sense in the context of abuse by first-time round asylum seekers. If you try and make those anti-abuse provisions work in relation to second-time round asylum seekers, you have to strain to make sense of the directive.
Well, we'll have to come to that when we see
I'll
Article
come
16.
back to that, yes.
Yeah.
So can I then turn to the the first of the textual points? There are really four, I should say, that I draw attention to, which are Articles 5, 6, 9 and 10. Can I start with Article 5, please?
I mean, I'm sorry, but Article 3 says scope. I mean, are we not going to look at it? I thought that's what we were discussing, the scope of this directive, whether it...
Yes. Well, Lord,
I mean, just tell me, if once a first-time application has been through the appeal process and has finally failed, is the applicant somebody who is allowed to remain on the territory as an asylum seeker? I mean, it seems to me that was just conceivably the only point you might take, but I mean, I'm not saying it's a good one, but it just seems to me we oughtn't actually to overlook it.
With respect, my scope argument is different from that. It is simply that the reception directive covers a particular field, and the text, as I say, it just doesn't make sense in respect of people who are coming round for the second time.
But it could be said that, and perhaps is being said, that Article 3 can be read against you, because it's saying that it applies to people so long as they're allowed to remain on the territory as asylum seekers. Look at the definition of asylum seekers, and you see people in respect of which no final decision has yet been taken. And that the rider at the end of Article 3.1 is if they're covered by such application for asylum according to the national law. So the national law allows them to make a further application. It hasn't yet been finally determined, and therefore it's within the scope of the article. That's the literal construction,
Yes.
which can be. You wouldn't dispute that you could construe the article that way.
On a literal construction, I have to accept that is a possible construction of it, but it doesn't stand alone.
But under the Convention, and indeed under this common European system, I mean, if actually, having failed in a claim, before you come to make further submissions, which may or may not amount to a further claim, the system was such as to be able to remove the person from the territory, that would be permissible, would it? He has no longer any...
Yes.
He's no longer allowed to remain.
Yes.
Very well.
But yes. Article 5 is the first of the provisions that that confer rights on individuals. Member States shall inform asylum seekers within a reasonable time not exceeding 15 days of at least any established benefits and of the obligations with which they must comply relating to reception conditions. Member States shall ensure that applicants are provided with information on organisations or groups of persons that provide specific legal assistance and organisations that might be able to help or inform them concerning available reception conditions, including health care. Now, the time period is one which is relatively short. It is obvious that the directive is contemplating the provision of this information quite urgently to these individuals. And it is information which a first-time round asylum seeker clearly needs to know quite urgently. What benefits are there? What are my obligations in order to keep the benefits from this directive? And who can give me legal advice and assistance or advice about reception conditions and healthcare? The first-time round asylum seeker really has a genuine need to know this and a genuine need to know quite urgently. But the second time round asylum seeker, somebody who has been through the system completely once, doesn't have an urgent need to know in the same way.
Well, you may be quite right about that, Mr. Tam, but could you not apply Article 16(1)(a) there and say, well, look at the third head of little a, this is somebody who's already lodged an application in the same member state. This is an article that allows us to reduce reception conditions. You've already got the paperwork, you don't need to have it again, and therefore we won't provide you with a duplicate set.
Yes. Our argument is that 16(1)(a), or the third tier A of 16(1)(a), doesn't deal with this type of case. That is not what that is about. That is about people who are making multiple concurrent applications, having come for the first time and abusing the system in that way. And there's an argument, the arguments that we make about that are these. There are three types of abuse that are set out in 16(1)(a). The first two are obviously abusive, that's to say disappearing or failing to report or provide information. One would expect that the third of those types of abuse to be of a similar nature. And there is a type of abuse of a similar nature, which is the making of multiple concurrent applications, and it must be said, often in multiple identities, so as to get multiple sets of benefit for one individual.
Well, the word used is, the words are has already, and that suggests a sequence rather than a whole lot of things lodged at the same time.
Or soon after one another. So lodging an application and then lodging another application, perhaps in a different identity, before the first one has been determined, to get another set of benefits from it. That is a type of abuse which is not only known, but is obviously of a similar nature.
Well, the underlying premise of this argument is that each of these is a species of abuse. Why should that be so?
Because, and this is the second point, because if you then look at the concluding words of 16(1)(a), so immediately after the third tier A, those words obviously apply to all three of the tier A's immediately above, and they refer to when the applicant is traced or voluntarily reports to the competent authority, a duly motivated decision based on the reasons for the disappearance shall be taken on the reinstallation of the grant of some or all of the reception conditions.
But that doesn't have any direct relevance to the third of what you describe as the abuse examples, does it? Why could it not apply simply to someone who has, as the word suggests, already lodged an application? Because, as my Lord has pointed out, that would sensibly relieve the authorities of the obligation to provide them with the information under Article 5.
If those concluding words did not apply to people falling within the third tier A, it is difficult to know, or difficult to understand, why the third tier A was put where it was put. Because if what 16(1)(a) third tier A is actually dealing with is people who have made an application, had it fully dealt with, and then are making a second, perhaps bona fide application, perhaps as a refugee surplus or a claimed refugee surplus, if that was what was contemplated by the third tier A, it wouldn't have been put there together with two forms of obvious abuse and immediately before a final provision which deals expressly with cases of abuse. The obvious inference to be drawn from the location of what's described in the third tier A is that it must be referring to a species of abuse which is similar in nature to the first two and which could also be described as a disappearance requiring a subsequent tracing or perhaps leading to voluntary reporting to the competent authority.
What about 16.2? Do you take
Yes.
anything out of that?
Well, 16.2 is a different point entirely. 16.2 deals with well, we all know from cases where people have arrived in the country and then don't claim asylum speedily and defer their first claim for asylum for some time, perhaps until after they have been picked up and are being threatened with enforcement action. 16.2 deals with this entirely different species of case. The person who has unreasonably delayed making an asylum application when you would expect that he ought to have made the application as soon as reasonably practicable. And what we say about that is that it naturally deals with the person who is making an application for the first time, because you can say, did you make your application on arrival? Did you make your application immediately after you've got here, immediately after you were let out of whatever transport you came in? But it is not something which naturally applies to an individual who has already been through the asylum system once, completely, had their asylum application refused, and then make a second one and say, you were wrong the first time round, I want to have another go at this.
Well, it could be. I mean, the example that Lord Brown gave earlier is a change in conditions in the home country, which has only now become apparent, and as soon as you know about that, you put in your repeat claim. You could apply the test set out there, and it would be equally capable of being satisfied.
The example would fit more naturally into 16.2 if 16.2 were worded differently. If I respectfully suggest this, that if it simply said that the asylum claim was made as soon as reasonably practicable, full stop, then the second time round claimant who says things have changed in my country and I'm now making this claim as soon as reasonably practicable would fall naturally into that. But what it says is as soon as reasonably practicable after arrival. So one sees again the reference to the time frame of arrival in the UK and a claiming of asylum expected to come soon thereafter. Just like in all the other provisions that I'm going to take your lordships to, one has to strain the words of the provision to make them fit the case of the second time asylum applicant.
The difficulty I have is that if it had been intended to confine this to first applications only, then it would have been the simplest thing on earth to do so. Whereas, and that hasn't happened, and instead you accept, as I think you have to, that on the literal interpretation it covers, the definition covers repeat applications, and so you're having to get out of all these other various provisions some implicit restriction of the definition, which we don't find explicitly, to first-time applications. It does prompt the question, why on earth, if you're right, didn't they just spell it out? It's the simplest thing to do.
I think perhaps we all wish that they had done. But if you look at a measure within the same system which was intended to apply to second-time applicants, one finds explicit provision made for it. So that's the first point. The second point is if you look at the language and you look at all the textual difficulties on each of these points, you get a flavour of the intention of the drafters of this measure, that they were clearly only looking at the first time round applicant. None of these individual points might be enough to get me home on this interpretation, because when you're looking at interpretation, you've got a choice between a literal meaning and a purposive approach. it might fall one way or the other. But if you look at this succession, and I'm going to come to the others, if you look at this succession of points which give a clue to the intention of the drafters of the directive, you can see that overall they can't have been thinking about the second time round person. They would have used different language. They would have made some provision for the second time round applicant, because these provisions as drafted simply don't make good sense in relation to a second time round person.
Mr. Answer, I'm a little bit stuck still with it. This word tiret, is it called? What's that mean?
Yes. Or bullet point, perhaps.
I've never heard of the word tiret. Anyhow, but it has already lodged an application. I mean, are you saying that it is simply incapable of applying to, say, further representations before a final decision is taken on an initial application? I mean, which could very well set the process back, delay it, complicate it, etc., etc. I mean, is it capable of applying to that or not?
No, because this is looking at abusive applications, and you can see that because of the words that follow on. All of these cases, because of the way 16.1a is set up, with the three types of case, followed by this reference.
So give me a paradigm instance of where it does apply.
An individual arrives,
Yeah.
he claims asylum at the port as Mr. A,
Yeah.
and then he goes away. 3 days later, he goes to the Home Office and says, I've just got out of the back of a lorry, my name's B, I apply for asylum, and then he may do the same thing again or again. That is a sort of abuse.
Well, that's a criminal offence, isn't it? I mean, if he's getting benefits in two different names.
Yes.
I mean, you say that this is directed to that situation.
Yes, because
Only
that does fall within the words of this case, has already lodged an application, and it is a case which is naturally being dealt with by those concluding words. Because then you have an individual, you don't know who he is, you don't know where he is. He may have been assigned to two different addresses, and getting.
Is it really dealt with by the country? I don't quite see how it's dealt with. How does it? Here's A, who's committed a criminal offence because he's tried to get succeeded in getting his benefits twice over as B. How does it work? Where the applicant is traced or voluntary reports a duly motivated decision based on the reasons for the disappearance. I don't understand how it works. Shall be taken on the reinstallation of the grant of some or all of them. I just simply don't understand how that works in the context in which you've just.
What happens is that if you have an individual like that, you may actually have no idea who he is or where he is. But you have discovered, perhaps from fingerprinting or identity checks, that it is in fact the same individual who's applied more than once. Then what you can do is to reduce or withdraw the reception conditions. To do that, you have to comply with 16.4, which is take an individual, objective and impartial decision on the reduction or withdrawal of the reception conditions. And then, when the individual is traced or reports, you then decide whether or not you're going to give him back any of the things that you've taken away from him. That is what these provisions of Article 16 are obviously aimed at.
Well, like Lord Brown, I must say I do have difficulties with that. I mean, the third tiret just doesn't seem to fit into what that rider is dealing with. It obviously does have some significance in the first two, but the word disappearance is so hard to apply to the third tiret.
It is until you recognise what type of case is being contemplated in that third tiering.
Well, if it is the type of case that you have set out for us, seems a remarkably inept way of expressing it. I mean, if you isolate the words from their context, and I'm not suggesting that's legitimate, but it wouldn't begin to convey all that you wish to import into the provision.
On its own, I accept that would be quite an obscure provision.
It takes a reasonably, at least I don't mean this in any pejorative sense, but it takes a reasonably contrived, not to say labyrinthine approach in order to get it to fit with your essential thesis, does it not?
Well, we respectfully say that if you look at it in context, that is to say, where does it actually appear in the provision? And you remember that if you're giving 3 examples of cases, you would expect the three examples to be of a similar kind. And then if you then look at the concluding words, which were obviously intended to apply to those 3 cases, and then you ask yourself, well, what sort of case does it apply to? That is the answer. Perhaps if I can turn it around and ask how natural it would be if the third point dealt with the legitimate sequential application, that is to say, an application made only after the individual has had his first asylum claim completely and definitively rejected, that is to say, the respondent's position. Well, it would be an extremely odd place to put this provision because it follows on in a list from a list of clearly abusive situations, but the respondents would say that they're not in that position at all. And it's sandwiched between those 2 abusive types of case and the concluding words which deal with those 2 abusive types of case. And one asks, why on earth would the drafter refer to the legitimate sequential application in the middle of all of this abuse? It would have been, if that was what the draft was intending to do, it would actually have been much more natural to hive it off completely into another paragraph and say member states may reduce or withdraw reception conditions where somebody is making a second time round application. In fact, one might have thought it would be preferable for this reason alone, that it removes that from the stigma of being lumped in with plainly abusive categories of case. But the drafter didn't do that. He put it where he put it, and we respectfully say that some meaning has to be given to that, some importance must attach to that, and that is how we come to the suggestion that we proffer about its meaning.
Well, is it helpful to go back to Article 5? I think I rather interrupted you on Article 5 and took you directly to Article 16. Is there any more to say about Article 5 and information and so on?
On Article 5 itself, no, but we say it is here the first example going in order of something that makes sense for the first time round applicant but is actually a bit odd for the second time round applicant. The second time round applicant doesn't need this.
Might the explanation for this, as indeed I think it's suggested by your opponents for some of the others you rely on, be simply that this caters both for obviously it caters for the first applicant, but there might be circumstances in which there is quite a long interval of time between the adverse decision on the first application and the second application. And we all know that lots of these failed asylum seekers are not removed for often years. And so might it not be that the drafters here were contemplating that it would be, as a belt and braces, if you like, that there might be changes in established benefits and all the rest of it, which have taken place during this potentially long interval of time, so that, and that's the reason why it's there and it does apply in respect of subsequent applications?
Clearly, it is possible to devise an explanation for how the drafter might have thought it applied to second-time applicants. But the purpose of Article 5 is clearly to impose an obligation on the state to push this information. And you impose such an obligation when the recipient of the information really needs to know that. Now, it may or may not be the case that somebody who has been right through the system may like to be updated, or there may be changes that they would like to know about. That is possible. Clearly, it is desirable that they should have access to that information. But if one asks the question, do they really need to know this to the extent that the state is obliged to push the information out to them? The answer is we respectfully say no, that need is simply not there. Indeed, if you take the example of these respondents to ground it back into the facts of the cases, individuals who have been represented, legally represented, I think throughout, and have no need at all of this. And we know that many individuals who appeal, and successfully or unsuccessfully, are represented, and they are people who really have no need of this obligation to push the information out there. We would entirely accept one can devise explanations, but they are unnatural and they are strained, and that is the point that we make over and over again in relation to these.
But if you look at the reference to reception conditions and look at the definition of reception conditions, that's the full set of measures which member states grant to asylum seekers in accordance with this directive. They could change from time to time, couldn't they?
Only if the directive were amended, because the reception conditions are the if you like, the benefits that the directive gives. So this information is one of the reception conditions which the state is obliged to provide.
The measures are not actually set out in the directive, the measures as such. You're told, for example, in Article 8 about families, that member states shall take appropriate measures. And they shall be implemented and so on. But my question really is, with experience and having regard to financial circumstances and so on, these could change from time to time. And so what might have been accurate in, let's say, in 2004 wouldn't be accurate in 2005.
Well, indeed, it is clearly possible that things may change over time. But one has to recall that the effect of learned friends' literal interpretation. Supposing, for example, an individual makes, he's been through the system completely for the first time. He then makes further submissions, which are, unlike on the facts of the present case, rejected and fully rejected quickly, perhaps in a matter of weeks. He then makes further submissions, and they're rejected in a matter of weeks, or possibly even days. And then a third set of further submissions, rejected within days. They might even be so bad by then that under the Procedures Directive they could be rejected as inadmissible, so that the substance doesn't even have to be looked at. The effect of learned friend submissions is that on each of those occasions the state is obliged, right at the outset, to give all of this information every single time. Simply if the man writes a letter and says, I can't go home, I will be at risk there because this has happened in the last week. That is the effect of the literal interpretation of these provisions. So that's even more.
That's right, is it? I mean, We haven't actually fully looked at the procedures directive yet, but I mean, if you're entitled to disregard it as totally, I mean, does it nevertheless, is it suggested constitute an application for asylum within the meaning of Article 2?
Well, if learned friends are right, and each of those further submissions constitutes an application for asylum because it's a request for international protection, then every single time a letter comes in like that, then all of these provisions are triggered, irrespective of the merits of the application. We say that that problem is even more stark if you go on to Article 6, which is the next of these provisions, that deals with documentation. In the case of documentation, the need of the individual is even more urgent. The obligation on the state is to provide the documentation within 3 days. The document has to be issued in his or her own name, certifying his or her status as an asylum seeker, etc. Again, we respectfully say, if you have just arrived in the country and you claim for the first time that you need international protection, you make a claim for asylum, of course you will need something to certify that you have that status. That is obvious. But we respectfully say, if you've been through the system already, and especially if you get into the cycle, perhaps, of these repetitive further submissions long after the initial application has failed, why should the state be under an unequivocal obligation to provide you with more documents every single time? Again, one can, in theory, work out some explanation as to why this might be desirable, some situations in which it might make sense for the second time round asylum seeker. But we make the point again, it is unnatural, it's straining the language to impose this obligation, it's straining the purpose to impose this obligation.
I mean, if you finally rejected the initial application, then the documentation has lapsed, because all that is certified, testified to, is the person is allowed to say while his or her application is pending or being examined. Ex hypothesi, that application is no longer pending or being examined. Ex hypothesi, that documentation has lapsed. I mean, if you make a new application, then you need a new document. Don't you? I mean,
what we focus on is the urgency of the requirement. The urgency of the, rather, there's a very short time limit which reflects the asylum seeker's urgent need for that. The urgent need is present, and obviously present when somebody arrives here for the first time.
well, say they've been here for months, and then, you know, they've been here as a student and all the rest of it, they're about to be deported, and so they make their first application. I mean, you accept they've got to get this within 3 days, right? They've got to get this document within 3 days. I mean, this is what? So that if any policeman then comes along and says you shouldn't be here, they can say, oh, yes, I'm okay, I've got this piece of paper which shows I'm an asylum seeker, is that it?
Yes, or if they need it for any other purpose.
What sort of purpose?
There may be requirements to show it at some stages of the process, but the first time round asylum seeker clearly needs a document because
But they need it to prevent, so that they're not going to be removed and deported, isn't it?
But after you've been through the system, we query the need for there to be such urgency about the provision of documentation, and especially where, if you go back to the situation where somebody is making these further submissions over and over again, as happens in some cases, whether that is really an obligation which sits naturally with the overall scheme of the directive.
Well, just to go back to my Lord Brown's point, if you have been through the system and you've been finally refused, does the original documentation, which you've been provided with, still prevent you from being arrested and deported, or do you require a new authorisation?
The document itself may technically have lapsed. Now, I accept that, if it is limited to the technical period of your claim. But you have the document. It shows that you have been an asylum seeker. And the urgency of having that replaced is something which we would respectfully query.
Is it not urgent to have authorisation in order to forestall the very eventuality that the first document is designed to deflect?
Yes. Well, the individual could say, I have the document here. I have made further submissions to the Home Office. They have not yet been decided. And if it's a question of being arrested for immediate removal, that is enough to forestall the problem. That person's in a different position from the person who's never had asylum seeker documentation and who is here having never had substantive rejection of his asylum claim.
Could you possibly give the statutory base for the in our legislation for permission to remain while the asylum claim is being considered?
Yes, we'll put chapter and verse together on that if we may.
And what happens? I mean, if the claim is refused, does a further decision have to be taken that the individual is to be removed, or does it automatically follow from the refusal of the application?
I think the question is, the answer is it depends. and so if we could put that together in a note, it will avoid our falling into error. I think there are some categories of individual who, if their asylum claims are refused, may still need a further decision before they can be removed. There are others who may be immediately removable as soon as removal directions are given.
Yes.
And I'm not sure off the top of my head as to whether or not the protection against removal is exactly the same in all of those cases.
And do removal directions, are they given simultaneously with the refusal of the claim? If the claim is found to be unfounded, would there then be an immediate?
Not always.
But sometimes it could be.
It could be, but certainly not always.
Forgive me for not knowing this, but is there a similar provision in the Procedures Directive about the provision of documentation?
I don't believe there is, because the Procedures Directive deals with the essentially the administrative matters for the substantive consideration of the claim.
But if the documentation which you present as a defence from removal lapses after your the final decision has been taken, what is there to protect you in the event? I mean, in the form of, sort of crudely, a piece of paper that you can present to a police officer. What is there that you can present to him unless the Article 6 applies to repeat applicants?
If the individual is still in possession of the document, he will still have the physical document. It may not say, or may no longer say on its face, I am protected against removal at the present time because I still have an outstanding asylum claim, but he is able to say, look, I have made a claim for asylum, I have now made further submissions even though my appeal's been rejected, check with the Home Office, you will see that this is true, I can't be removed at the present time. That will trigger a line of inquiry. That person is in a different position from the person who literally has nothing.
Well, I quite appreciate that.
And that is why we draw attention to the distinction between this type of case and the other.
Sorry, could I just put this point to you? If your thesis is right, it would be far more sensible, surely, to make a provision in the Procedures Directive for the provision of documentation, albeit at a more relaxed, after a more lengthy period of time.
Yes, it would have been, and this is the point we make, that if the drafters of the reception directive had in contemplation the second time round applicant as well as the first time round applicant, he would surely have done what was in fact done in the procedures directive, which is to say, first time round applicants get this, second time round applicants get this. There's a more relaxed timescale, there's less need, we recognise that this has to be dealt with here as well. And it is the absence of any of those provisions, coupled with the word reception in the title, and coupled with the possibility of abuse, that leads us to say that clearly that was not what the drafter had in mind. And this is the second time round person was simply not within the field of the directive.
Yes, but the other way of looking at it is the absence of any provision in relation to the documentation in the procedures directive supports the notion that it was based on the premise that, so far as Article 6 is concerned, that documentation would be provided to the second-time applicant.
It might have been, but we say if one looks at the practical reality, it makes much less sense. That these provisions all make perfectly good sense for the first-time round applicant. But when you try and apply them to the second time round applicant, you have to work quite hard to get them in there. And that is why we say there is something wrong here.
Mr. Tabb, can I just ask, a final decision, is that a final decision by the Secretary of State, or is it not when the whole appeal process has run its course?
When the whole appeal process has run its course.
So that in answer to my Lord Hope, I mean, you must have another decision, because, I mean, the final decision is not going to be the Secretary of State's decision on the appeal process. It's going to be whatever it's going to be. I mean, it's going to be either the IAT or possibly the Court of Appeal or possibly the Supreme Court, isn't it? I mean, refusing leave, is it?
Yes, I mean, the point at
so
which the individual...
So you then need a fresh decision in order to deport the person.
Or you may, in some cases, simply need to set removal directions at that stage.
I see.
Clearly, the time at which an individual's application is finally determined and there is no further recourse to anybody is one which is going to be uncertain at many stages. Because even after the Supreme Court, if a case gets here, the individual might make an application to Strasbourg, and the Secretary of State may not remove the individual while the application is pending. And so many things would remain uncertain. And so the actual setting of removal directions to get the individual out of the country is something which would follow at some stage, yes. So that the timing is all uncertain.
I'm puzzled now as to how Article 6.4 works in that extended timetable, because read in isolation it would suggest that Member States shall take appropriate measures to ensure that as long as a person is authorised to remain here, they have a document which indicates that that is the position. And that would apply all the way through, I would have thought, until the point comes when they're no longer authorised to remain.
Yes, and then the document would cease to be valid.
Are they authorised to remain after a final decision has been taken adversely?
No, because they would then be unauthorised and they're then obliged to depart. but the enforcement of that departure by removal directions may take time.
Yes. So there could be a long period of time when they don't have the protection of the certificate, the original certificate. They're not authorised to remain. And then they make a subsequent application.
Yes, a substantial period of time could elapse after the first documents are issued. That is true. But equally, there may be other cases in which the pattern of the making of further submissions means that this obligation is triggered in full every few weeks, or perhaps even every few days, in the case of people who are making further submissions over and over again just before removal.
Well, that's an extreme example, but take the perfectly meritorious case, and going back to Lord Brown's example earlier today, of somebody who can say that conditions have changed dramatically in the home country, and there's now a much better case for seeking protection than would have been the case earlier. You've just said that because the first application has been turned down, no longer authorised to remain, and yet there's an application now which, on that example, would stand a good chance of actually being successful, but it has to take time to be looked at. Why not give them the protection of a document to keep you here in the meantime?
Well, as a matter of fact, there are provisions of domestic legislation which prevent the individual being removed. I think that's in the rules, while the further submissions are being looked at. So,
Yes.
as a matter of domestic law,
Yes.
there's no difficulty. The individual is not at risk. But the question is, did the directive contemplate? Was the directive really dealing with that situation, or was the directive really only looking at the first time round, leaving the other matters to the member states?
Well, it's helpful to look at it that way. The framer of the directive wouldn't know anything about the domestic rules in all the various member states, so he's framing a system. He's setting out a system, isn't he?
Well, it's setting out minimum standards. It is not saying this is how you will all do it, and this is a complete code for it. This is saying, for these people, whoever it is who fall within the scope of this directive, this is the minimum that you must do. But it does not say you must not do any more for them, and it does not say, in fact, I think it actually expressly says you can do more for them if you want, and it does not say that for people falling outside the scope of the directive, you make no provision at all, or and you leave them at risk. Our domestic law does cover these other areas, and it does cover them sensibly. And there's no need to stretch these parts of the directive to make our domestic law work, and that may be a reason why there's been no litigation about it, because as a matter of fact it causes no difficulties in practice. But if one is looking at what the directive actually says and asks the question, is it really supposed to cover that area? Is it really supposed to cover this type of case? If what we say is, if you are having to strain every time to try and find how these things work for a second time round applicant, and especially if one gets to it may be an extreme case, but it's not uncommon to find it, uncommon cases triggering rights over and over again when it makes no sense to do so, as we say, that is an indication that something is not right with that approach to interpretation.
Well, is that all on Article 6?
That's 6.
And we look to Article 9?
Can I deal with the other two, which
Yes.
are 9 and 10?
Yes.
9, medical screening. Again, the approach is the same. If you're dealing with somebody who is in the asylum system for the first time, many people coming here and claiming asylum as their first step when coming to the country, medical screening makes sense. If you have an individual who has been through the asylum system once already, and not only been through this possibility of medical screening, but also then had access to health care throughout the time that they've been here, why would the directive require, why would the directive make express provision for medical screening?
I mean, you accept it applies to somebody who's come here as a student, he's been here 5 years, and he applies for asylum.
Yes. It's not that the concept of being careful for people's health is odd. What is odd is finding the provision relating to a second time round applicant.
Well, it is permissive.
It is permissive, I accept, but again, it's all of a piece. What one sees is this pattern. Every time you say, you look at it and it's fine for a first time round applicant, but it looks a bit odd when you're dealing with a second time applicant. And then Article 10. Can I ask to look at Article 10 in more detail? This is an obligation, not permission, an obligation to grant to minor children access to the education system under similar conditions as nationals of the host member state, for so long as an expulsion measure against them or their parents is not actually enforced. So this is a right, an obligation on the state and a right on the child, to be educated until actual expulsion. It persists beyond the end of the final determination of the asylum application and goes right up to actual expulsion. First time round applicants, that makes perfect sense, and then the children stay in school unless and until the family are actually expelled from the country. If they apply for asylum again, you have to strain to find how this works. Learned friends have suggested an example. Obviously, one can find an example, but it is, again, strained and unnatural. But can I then also draw attention...
Why is it strained? I mean, what they say, as I understand it, is, well, it applies to repeat applications where children who were not of school age at the time of the original application have now become of school age. Well, that must be quite a common feature, I would have thought.
Well, clearly, it will happen, and we don't say that any of these literal interpretations is impossible. But that is, perhaps I can use this phrase again, one has to work quite hard to find the category of people for whom this has any real effect.
So I'm not quite sure why it is necessary in Sir John's illustration. I mean, assume that initially there was no right, but there it is, there's a further application. I mean, why? I mean, it's just in bald terms, as long as you're not expelling this person, you have to grant access to the education system.
Yes. If you have a person who has been through the asylum system once already, you've got all the way through, and if you have children who were going to school because of the Article 10.1 right, on a second time round application, you simply don't need the Article 10.1 right at all. Well, because the children are already in school and they are entitled to stay there until the family is actually expelled.
Yes, I think I follow that. But the example, the point raised was what about the position where, if you look at Article 10.2, during the 3 months from the date of the application for asylum, there wasn't actually a child who was of the relevant age. But now 2 or 3 years have gone by and they've got older, and now they are minors who would be entitled to be provided for.
Well, that's a respondent's point, but our answer to that is this, that is, we say, working quite hard to find a category of people for whom 10.1 actually has any real effect. And even when you've isolated that category, you can still ask the question, well, is that actually the right way of reading this? Because the Article 10.1 right is not actually limited to children of school age. And it is perfectly possible to read 10.1 as applying to children who are not yet of school age, but who benefit from this right for as long as the family are here, so that when they become of school age and national children get to go to school, they also get to go to school at the same time.
Well,
and indeed, that's what one would expect.
Indeed, it's a very sensible way of approaching it. But how does 10.2 work? Because there is a time limit there. You can't postpone access for more than 3 months after the date of the application.
Yeah. 10.2 is another problem for the respondents, and a completely separate problem, which is that 10.2 permits the state to defer that access for up to 3 months.
Well,
or 1 year in certain circumstances.
Yes.
If you look at the family whose children go to school under 10.1 on a first-time round application, and then they make a second-time application, 10.1 already has already given them the right to be at school and remain at school throughout this period because the family have not been expelled. The 10-2 power to postpone then makes no sense at all, because there would be no question of postponing access.
What's meant by specific education? Is that special needs or something of that kind?
Possibly so. That's certainly the way I read it, and we can find out.
After a language, or no, probably not language.
It may be special needs. It could be language difficulties or whatever. But clearly that there's a category of case where you might postpone for up to 1 year. But if Article 10 applies equally to first time round and second time round applicants, why should there be a power to postpone access to the education system for 3 months for the second time round applicant, when actually 10.1 has already granted them continuing access throughout this entire period?
Is there a general point here that this is, by definition, supranational legislation? It has to be drawn at a fairly high level of generality, doesn't it?
Yes, and it's couched in language which one recognises from other contexts.
And drawing on specific examples to try to illustrate what you say are anomalies is a somewhat difficult exercise given the nature of the legislation, isn't it?
Yes, and it is easy to point out the anomalies that are thrown up by the respondents' construction of the directive. And we have done that in relation to a number of these articles. Those
difficulties are compounded by the consideration that, as Sir John has pointed out earlier, all of these problems would have been avoided by a single stroke of the pen saying that this doesn't apply to second-time applications.
That might have been one way of dealing with the problem.
Was it not the obvious way of dealing with it, given the nature of the legislation?
Well, if the drafter had wanted to make clear or clearer that it did not apply to second time round applications, then obviously saying so expressly would have been one way of doing it. But if the drafter thought that it did apply to second time round applications, one would have expected him to have addressed his mind to some of the anomalies that are clearly present in the current draft or the current version of the directive in relation to second time round applications. For example, he could just as easily, with the stroke of a pen, had said in 10.2, except for people who are already benefiting under 10.1, you can't postpone, or the power to postpone doesn't exist for families where the children are already at school. It would have been a very natural thing for the draftsman to have done. And going back, well, I've made the points in respect of 5, 6, and 9. So these are the drafting oddities that would exist if the respondents are right and if this directive applies equally to second time round applicants.
Now, are these the only ones? You've referred to 4 articles. Are there any others that you say throw up oddities, or can we take it those are the ones we need to concentrate on?
Those are the ones we ask you to concentrate on. And then in relation to the possibility of abuse, it's the 16.1A, yes. And just what on earth does the third tier A of 16.1A mean?
Yes.
And does it really apply to these cases so as to deal with the possibility of abuse there? Also, some of the points I've dealt with as we've been going to and fro in the course of argument. But we have referred to the situation in which the failed asylum seeker makes further submissions and then further submissions and further submissions after each successive set has been rejected. And we've drawn attention to the anomalies that are thrown up by the respondent's construction of the directive if that is a situation that applies. But the respondent's interpretation throws up even more anomalies if one considers even more extreme examples, extreme in the sense of their place in the logical order, but certainly not uncommon and not unknown in real life. For example, if the individual, having been through the system completely once over, makes further submissions, and then before they are dealt with, he makes yet further submissions on a different basis from the first set of further submissions. On the respondent's approach, that would also trigger all the reception directive rights again.
How does the system actually work in practice? Let's assume as a first-time applicant. The applicant is entitled to make further submissions before that first application has been considered and determined. Is that right? Further submissions will be received.
He's entitled to say whatever he likes to the Secretary of State at any time.
Yes.
And the first time round applicant would have those, as a matter of practice, would have those looked at as part and parcel of his application.
And if there's an appeal, is it still possible to put in further submissions in support of the appeal, all related to the first application?
Yes, it would be. There are some specific restrictions on grounds of appeal which are complex, but in terms of asylum applications, which is in this field, it is not unknown for people to raise further matters on appeal.
I may be wrong, but I thought the statute actually directed the person dealing with the appeal to take account of submissions made in the course of the appeal.
Yes, that's right, and the further submissions that are made would have to be looked at by the immigration judge. So in real life, when the person makes his asylum application, he goes through the system, he ends up in appeal. Those submissions do in fact get looked at. The difficulty is that if you take the reception directive and take the strictly literal approach which learned friends suggest, you'd end up in a situation where each of those sets of further submissions triggers the reception directive afresh.
Well, that's what I found, why I put the question.
Yes.
If it doesn't have that effect on the first time round, why should it have the same effect the second time round?
Well, I think the ultimate destination of the respondent's submission is that it would have that effect even on the first time round. And certainly it would have that effect the second time round.
Are you suggesting then that each time further representations are put in, that qualifies as an application for asylum within the meaning of the definition?
On the respondent's approach, that is exactly what they say. Or if it isn't, I'm sure learned friends will explain in due course. But that appears to be the hard-line, literal approach being taken.
I'm sorry, I mean, if the Secretary of State chose to deal with 353 differently and looked at further submissions and said, terribly sorry, this isn't a fresh claim, I mean, how does it work then? I mean, presumably, on that basis, then the reception directive doesn't apply.
With respect, no. If the Secretary of State were to adopt the practice, which he doesn't, as a matter of fact, of looking at the further submissions and deciding first whether or not they were a fresh claim, and then going on to decide whether or not to accept or reject the submissions, We, of course, say that none of that triggers a reception directive. Learned friends, I apprehend, will say that, one, it triggers a reception directive, and two, the decision that it's not a fresh claim does nothing because it is not something recognised by the reception directive.
The fresh claim procedure is really a mechanism to allow the person to appeal. Is that right? I mean,
Indeed, well, that is its effect. It is only of practical importance in deciding whether or not the individual has a right of appeal.
Yes.
If his substantive submissions are rejected.
Because if the Secretary of State is persuaded by the fresh application and actually grants the right to remain and so on, there's no need to certify under 353 at all.
Exactly. It just becomes academic. And that is one of the key reasons why fresh claim, the question of whether it's a fresh claim, is only looked at after the substantive decision has been made,
Yes.
because that's really the only thing that it's important for. So none of these problems will be solved by looking at fresh claim first on the respondent's approach to the construction of the directive.
Well, where do we go from here?
Lord, I'm just going through this. I've had notes to draw your Lordship's attention to the dicta in Onabio and BA Nigeria about the real possibility of abuse of the system, but I suspect that would be treading ground that it's not fertile to go on, given how recently your Lordship's been looking at it. We've made a reference in our case to the dicta of Mr. Justice Stanley Burnton, as he then was when refusing permission to, I think, ZO, which is in the... can I just give you the reference to that? It's in Appendix 2, at pages 271 and 272, paragraphs 6 and 8. But he's really, I think, there saying what is common experience of the courts of the way in which abuse takes place.
Paragraph 1.6, is it?
Yes, 1.6 and 1.8.
Yeah.
It looked like an artefact of the printing. What's printed is 1.6 and 1.8. Which is all of a piece with the earlier observations in Onabio and VA Nigeria and indeed the other cases dealing with this. That it seems to be common ground that that the possibility of abuse is a legitimate tool for construction of European materials, just as it is for domestic materials, and that, of course, makes sense. And it's for all those reasons which that we say that the distinction that we ask to draw between the people who are going through the system for the first time round and those who are making further submissions following a definitive rejection is a legitimate distinction to draw, and one which can properly be reflected in the construction of the directive. And that is why we get to Article 16 and pointing out that if you look at what Article 16(1)A provides, and especially the third tier on which learned friends place so much reliance, that actually that is not what it is dealing with. And the directive on learned friends construction is wide open to the sort of abuse against which the courts have warned repeatedly.
Well, would that be an appropriate point
Lord,
to which to raise?
indeed. After the short adjournment, can I say I have left on the directive to deal briefly with the Dublin Regulation and Procedures Directive, yes, and a handful of other points on this first substantive issue.
Well, we'll see you at 2 o'clock.